If I can hitch a ride on Joffre's interesting question, if I may, Joffre, the personnel of a grand jury in America are not the judiciary, they are ordinary citizens. Is that correct?
Yeah, they're drawn by the sheriff is the guardian of the courts. The sheriff is the chief officer of the crown, is the chief law enforcement officer of the state. So the sheriff is more important than the judge. In fact, when the judge gets out of line, it's the role of the sheriff to intervene, because the role of a sheriff is to ensure that people can exercise their rights in court in safety. That's their mission statement, straight off their website. The sheriff is to ensure that people can exercise their rights in court in safety. So what happens in here, we have the judge or magistrate say, no, you can't have a trial by jury. That's when the sheriff is supposed to stand up and say, come with me, boy. Yeah, honestly.
That's the American grand jury system. Therefore, is more democratic than what we have here. That is what you are saying.
No, the grand jury is more or less a referendum station. You know, it's to decide if a case is worthy of going on to a trial jury.
Understood.
In cases of serious offences and maladministration.
Thank you. Gary, yes.
It's a second question.
Yeah.
Oh, I'm so sorry.
Sorry, the second question is, can the jury system be applied in the legislature, and do you think it's a good idea?
Well,
Sortition.
the legislature is, in our system, the king. Because when you look at the Constitution Act of 1902 for New South Wales, it says very, very clearly in Section 3, the legislature is the king.
The king.
The king, with the advice and consent of the House of the Legislative Council, Legislative Assembly. So the legislature is the body for making laws, but they make statute laws. They don't make common law. So trial by jury is in the common law system, is the people system. Okay, and because when you have statutes, they can make any old bad laws they like. In fact, they even say, the courts will consist of a judge only. And that's absolutely incredible. You can't have it. That's been coming in for the last 40 or 50 years, yeah? Where they say, but they also, previous to that, they've always had the phrase, the court or a judge will do this. The court or a judge, okay? So the only way you can have a judge only is with consent. Otherwise you've got a court. And a court, according to A.V. Dicey and all these people, very learned men of the past, they said, no, an ordinary court is constituted by a judge and a jury. And the jury are the judges, and the judge is just there as representative of the state to enact or put into effect what the jury decides. In fact, I had an argument with one judge. And I said, you've got no jurisdiction. And he said, what do you think I'm here for? I said, you're here to do what the jury tell you to do. And he didn't like that because they think they are our masters. And we are the underlings, we're the subjects, the underlings. It's not so. It's the other way around. In a democracy, we have sovereignty.
Okay, yes, Gary.
In your vision, do you see the jury being a professional jury,
No.
or like randomly selected from the public, constantly renewed?
It's your duty to, as a community, to protect the community, your neighbours and whatever. You say you can't have a professional, because profession means paid and standing. You can't have a standing jury. Because that might be all right in cases of a grand jury, where the grand jury might process half a dozen cases in an afternoon. But they only decide if it's worthy of going to court. They've got no teeth. They've got no power. So as far as in the legislature, In fact, even in the Constitution, as it was intended to be, it says that if there's any dispute in the Senate or the House of Representatives, that's all dealt with by a jury in that environment, which is, again, going back to their equals. Right? So the legislature and the Senate or the representatives, they can hold their own court in the Parliament. But if they feel they're being unjustly dealt with, they can then up the ante by going to a common law court, an ordinary court.
Yes, Jim.
Are there any nations on earth that actually follow their own correct rule book? So the flip side of that same question is just how corrupt is our system compared to other systems around the world?
Well, I don't know every country in the world, but I know that in America they more strictly follow English common law than we do, because when they had their War of Independence, they're part of Jefferson's Declaration was that they had been denied their ancient traditions and rights. So they made damn sure that when they got their divorce or separation, their independence, that they put into their constitution trial by jury. They had this Mickey Mouse figure of $20 as a starting point. But no, the Americans more strictly follow the correct procedure, but that's not constant throughout the whole of the states. Because in some states, they still have this wrongful situation where the jury are dismissed after they give their verdict, and the judge steps in. But in other cases, in other states, the jury gives their verdict, and then they're brought back for the sentencing hearing. They have two, and this is where all the mitigating circumstances come in and say, oh, I've had a broken childhood, and they can argue anything like that. Because the jury decide, yes, he's done wrong, because that's what guilty means, done wrong, and then they decide the judgment or the pronouncing of sentence. Or in some cases, they decide the benefit. If somebody's been unjustly treated, they will decide the damages to be awarded. And even in our Jury Act, it says the jury determine the amount of damages, and that's the judgment. So, as far as England is concerned, they are going against their Magna Carta, and there's quite a big movement over there to reinstate their rights. And you see a lot of YouTubes where people are standing up and challenging the jurisdiction of the court. They're doing it in America, they're challenging the jurisdiction of the court, because challenging the jurisdiction of the court means that as soon as that's done, there is an immediate mandatory peremptory stay of proceedings. Stop, you can't say another word, until the jurisdiction is decided by a special jury. So in other words, you've got a jury deciding you've got the right to trial by jury. And the corrupt judges know that. That's checkmate. So they won't allow it. They said, oh no, jurisdiction, we've already decided we've got jurisdiction. Against the laws of natural justice, you can't judge your own cause. They don't care. They just throw due process and natural law out the window.
So which nation has the fairest system in terms of adhering to common law?
Well, in America, as far as I can tell. And in fact, it's very strong. They've got a very big organisation there called the Fully Informed Jury Association. And that's in 50 of the 52 states, whatever it is. And they have conventions where they have the top attorneys, the top jurors, and the top academics all getting together to discuss their constitution and how the courts are supposed to be adhering to it. That's a very, very strong movement.
Yes, Robert.
Would you like to comment on the 1986 Australia Act, which took out reference to the laws of England?
Well, it's a nullity. That it is totally null and void. Because number one, we became a Commonwealth on the 1st of January 1901. And as soon as you become a Commonwealth, there is no more king. But we've been lied to ever since, and they've kept this myth of the monarchy and how the Queen appoints the Governor General. And that's all A lie. Because that was all terminated. Even the High Court in England, back in 2005, they had a fellow called David Fitzgibbon. He brought an action from Australia into the High Court in England, and he was complaining about not using the right seals in proclamations and so forth from the government. And the judge in the High Court of England and Wales said, well, that constitution, that act, that English Act, ceased to have any effect. Ceased to have any effect once Australia became independent. And Australia became independent on the 1st of January in 1901. Later on, they also had the League of Nations, and that was again confirmed that Australia is a sovereign country. So all these things which are supposedly given royal assent, it's all nonsense. So all these bills for acts that went from the Parliament House to the Government House of the states or federal, they're worthless. That's only worthless.
The other thing is, what are we actually classified? What's this country classified as? Is it a Crown Republic?
No,
What
no, it's a common law country.
Okay.
No, I don't think he means that. I think he means how are we classified according to the way independent nations are classified. Are we a republic? Are we a monarchy? What are we?
Well, the term that I've heard most of it is a constitutional monarchy.
Right, that's it.
That's the word.
Yeah,
used,
I think
but-
that's a good one, yes. Okay, let's have the next one. That's you at the back, sir.
Yeah, okay. Look, my understanding of the Magna Carta, the Great Charter, was that it was between the king and the barons. When they talk about the people having rights, they really meant the barons, and it's the barons being judged by their own peers. So the intention of the Magna Carta is always to keep power within the hierarchy, and it wasn't really given to the common.
That's why you got to read it and translate it word for word.
Oh, I know people have gone over it forever, but when they actually wrote it, that wasn't their intention.
It was their intention.
You reckon?
It has the rights of free men. That's why it says around the top there. It
Yeah,
starts
well,
off, no free
I think they
man.
referred to the barons as
Opposed to serfs.
Well,
serfs.
the barons might be included,
Yeah,
but
it's
the
just-
overall concept.
Later, it sort of changed later on, but
No, it didn't change later on because it enforced
have you
the
read it
rights of
later?
free men.
well, I'm totally in favour of it, but that's not what they were doing.
No, but the lawyers will say, oh, no, that was the barons looking after the barons, you know.
Yeah, it
But
was.
that's why it comes down to Article 39. It doesn't say the barons will have trial by jury. It says free men.
Yeah, but it's only the barons
Has
who
it
free,
been made
nobody
free
else
since
was.
that time?
No, everyone is free. Free is in your mind.
Oh,
And in fact, the Bible says that we have liberty in Jesus Christ. That's where freedom comes from. If you want to get into that.
Okay, yes, Brian.
Thank you, David. I'm happy to see that journal. Oh, by the way, I apologise for being late. I'm not normally like that. Friend I had an engagement elsewhere, but I'm so sorry that I've missed it. No, I don't. I'm not going to. Unfortunately, otherwise you'd never shut me up. But what was I going to say? Yeah, I'm glad to see you're an old military man. Now, I've been in the military too, but obviously not as distinguished as yourself. But I would guess. But I'm 81, but so you're not. But anyway, be that as it may. When I first went in there, now they're giving some kind of constitutional rights. I mean, this was the British, and I rather fancy with the same Australians. They said if you were court-martialed, you could elect to be tried by your peers. That is by your fellow servicemen. And the sergeant quite wisely said, he said, I would advise you against doing that, he says. He said, your fellow peers generally can't wait to put a rope round your neck, which I think is true. He said, you'll get a much fairer deal from the officers. And I think that, and my experience in the military, I don't know about yours, I don't think that's about right.
Well, the essential part of trial by jury is to have jury selection. So if he was silly enough to select one.
But you can volunteer yourself out.
Yeah, no, in fact, there was a referendum question back in 1988, which they tried to alter Section 80 to exclude. They wanted to exclude contempt of court and court-martials from trial by jury. In other words, you must have trial by jury in contempt of court, you must have trial by jury in court-martials. And the people said, no, you will not exclude it. So that's why the alterations they proposed for Parliament to get rid of trial by jury for contempt of court, which would give all the power to the judges.
I'll just come back on that, because the British and I think Australian system is that murder, rape and treason is a civilian offence. You cannot be court-martialed for any of those offences. Americans it can, it's different. But you cannot be tried for murder, you cannot be tried for rape, and you cannot be tried by treason by the military. It is a civil offence.
Well, you have the rules and regulations, but all those offences are common law offences.
Yeah, sure. But I'm saying, but the American military, given America, they can try you for those, and you know.
They're going outside common law.
But anyway,
Common law is the superior law. Common law is democracy.
well, democracies are kind of a very malleable beast, isn't it?
Yeah, they said two cheers for democracy. It's the best system there is.
Yes, Steve.
Yes, you talk about common law a lot, but I was taught that common law is about the weakest law you can have, and it can be overridden by a bylaw by a council. Now, that's what they keep teaching.
Yeah, they're lying.
They might be. Why? What I'm saying is, are they really lying?
Yeah.
And why is common law so weak?
It's not weak. It comes from juries. Common law is the law of the people, by the people, for the people. It's a superior law in a democracy where people have sovereignty. Common law is the top law.
Are you saying common law just as for juries or other common law?
No, common law is applies to everyone because we are people. It's our law. And in a democracy, we are sovereign people. We are sui juris. We are our own master. And that continues into the jury system, where you have your equals, who are also free men, sui juris.
Well, maybe I'm getting it confused.
Yeah,
Maybe they're confusing it with customary ideas
Well, that's
that
why
people assume
yeah,
are common laws.
that's why you've got to go to the Oxford English Dictionary and get the right meaning of the word.
But you'd have to go further back. You'd have to go to a meaning of the word itself, which is
Right,
not exactly
in
the
fact,
same dictionary.
in the Parliament House in Canberra, they've got a big display of the confirmation of charters. Okay, this is 1297. That is confirming Magna Carta. And it says very, very clearly on the first page that the Magna Carta is the common law. They're the words. Magna Carta is the common law. And so if you want to go back to 1297, this is because Magna Carta was before they had any parliaments. The first parliament was 1256.
Simon de Montfort.
Yeah, that's right. And so they said, okay, we've got this great charter protecting all our liberties. We ought to confirm that as an act of parliament as well. That's why they had the confirmation of charter. So the confirmation of charters is a statute, whereas the Magna Carta is not a statute because it's before the parliament. It is actually a common law written because it came from the people. They had clergymen and barons in that church in Bury St Edmunds. They'd all gathered together. It wasn't just a handful of barons.
The point you're
No,
making.
I'm not suggesting that you're wrong. I'm just saying I wonder where this confusion set in, because I often hear it.
Yeah,
I actually saw it in a law course.
oh yeah.
They actually structured that and said this is the.
In fact, there are publications from the Parliament in Canberra which says that common law is judge-made law. And there couldn't be anything further from the truth. The judges are not people, they're agents or servants of the Crown. They swear they swear to well and truly serve. They are servants of the Crown. They are not part of the people at all.
The Crown being the government.
No, the Crown being the Queen.
Yes, go on, thank you.
Yeah, I understand the concern around courts having so much power and taking that power out of people's hands, especially to deal with corruption and that type of thing. But I was reminded tonight about a documentary I saw about an organisation working in the USA to help free wrongfully imprisoned folk. And they were saying the jury system there is just appalling. What's happening is that they're getting jurors that have no understanding about law for a start, but also the complexities of understanding these situations. And the other thing they were saying is that the problem with prosecutors and that type of thing is that they just need to create the illusion of the truth. They don't actually have to. They just need to convince the jury this is what's happened. And that type of thing. The flip side to this too is that a lot of criminals are apparently getting off as well. So I feel like you're caught between a rock and a hard place. The jury system is rife with issues, problems as well, as you pointed out tonight too. The judge can influence in this type of thing. I don't know. Do you have any thoughts around that idea?
Oh yeah, in fact, I had a letter from a juror in my case, and he said that the sheriffs came into the jury room threatening the jurors.
So do you think
that's
the
how-
jury system
that's how corrupt they are.
it will work, but it needs to be structured in a better way?
Well,
than it is?
even under international law, the International Covenant on Civil and Political Rights, Article 14 says that you're entitled to a public hearing before a competent, independent, and impartial tribunal established by law, and that's just understood. You don't want a bunch of deadheads, and that's why you have jury selection. And
Well, I did take note of that mention. You mentioned earlier as jury selection, and yeah.
because in some cases, I think in the O.J. Simpson trial they went through 600 potential jurors. Went on for 3 months before they agreed. Both sides agreed on 12 people.
That's a black white issue though, wasn't it?
Yeah, even up in Brisbane a couple of years ago, they went through 500 potential jurors before they selected 12. So that's why you have jury selection. The Americans call it voir dire, which is jury selection. But that is an essential part because you've got to have something you feel competent with and is your equal and will understand the situation.
Yeah, it's just that they're up against lawyers who are amazing mentalists. They're probably successful not so much for law, but just what they know about human.
Yeah, that's right.
That's
Yes.
right.
They're good gymnasts. Yes, Peter?
Yes, thank you very much. Give us a great talk about the jury system. I just want to ask two questions. The first one is do you think a jury system itself? I mean, I know it's a compare other system. It's a lot better system, but is it sufficient enough? Because when you're talking about Magna Carta, but we also can go beyond Magna Carta. We can go to the Greek times, which is the 400 BC. So when you're talking about the trial of Socrates, was also conducted by a jury, about 200 people. But that was a tragedy because they basically judged Socrates to death, to drink the hemlock. But also in the modern times, we can use the O.J. Simpson as an example. That is, even you say, well, they spend so much time and effort to select a jury, but the end result was also tragic. So in that case, if it's judged by the court, probably he will be found guilty. So my second question is just follow the first question. So even with the jury system, even we are guaranteed for that right, but also in order to produce real justice, the other side of the thing also, every defendant must have the access to the best counsel, which in the capitalist system is very difficult because it's all depending how much you can afford. And O.J. Simpson is a good example because he's a very wealthy man. He can afford a very, very expensive counsel. Thank you very much.
Thank you.
Well, that's what it's down to the jury to decide if somebody's got an eloquent speaker and somebody's got a stumble motion, but they've got to decide upon justice. So it comes down to the juror to conduct a fair trial and come up with a lawful judgment according to their conscience. And so many famous judges in the past have said the jury can go entirely against the evidence, entirely. So it's up to the jury every time to determine. That's why they've got a competent jury. As far as a jury back in the Greeks times, that's not the jury as we see it, because the jury in English common law is 12 people, and there must be unanimous decision and judgment beyond the reasonable doubt. This is why you have, if you've got 1 out of 12 say, no, I don't agree, well, that's a mistrial, it's a hung jury. And that's the way it should be, because you can't have a majority verdict, because there is still a doubt. And you can't have somebody being punished while there is that doubt. So it's entirely down to the jury as to how competent, independent and impartial they really are. But you've got to have a fully informed jury, and a fully informed jury should be aware of, well, there is something not quite right here, and it's up to the jury. They are doing the trial, not the judge. So the jury are perfectly entitled to ask questions during the course of the trial.
Okay, let's have somebody else on the block. Yes, John?
I just want to ask, don't you think it would be very cumbersome to have a proper jury system, like for every detail, to have parking fines, minor dispute and all that? And the second question is that, how will you select juries? And how many people are truly informed? I mean, it's I don't think I could be in a complicated case. I don't think I would be a good juror, because I wouldn't know, for instance, say something about somebody putting special chemicals into food or murdering somebody in a different way that most people wouldn't think of. So how would you know these things, and how could you select jurors? I mean, it'd be a very cumbersome procedure.
Good question,
That's up to the prosecutor and defendant, or the plaintiff and defendant, to decide if that juror is competent. So he can go through
600.
Yeah, more. Yeah. But like as far as having expertise, there's another legal maxim that says justice is when the jury have the best knowledge.
Exactly.
That's what it's all about. That's what you're saying. So if they're insecure about something, they've got to pursue it. And if they want to subpoena witnesses, they say, oh, we're not so, we don't fully, we can't take on board all the intricacies here. We'll have an expert coming in and explain. That's supposed to be the role of the judge. The judge is supposed to be there to explain and clarify to the jury. And if the jury is not satisfied, they're still insecure, they can call in anyone they like to give testimony. Because it's trial by jury. The jury...
I understand that. But how would it... I mean, you said also that the public should be educated. Well informed. I mean, but how many people can truly... I mean, you have to re-educate a lot of people.
Well, that's where it comes down to cases. So if you have a complex issue about patents and copyrights and so forth, you say, okay, we've got to have the best knowledge. We're the jury, we're the judges in this case. We've got to have the best knowledge, so we'll draw in the experts, and we'll be satisfied with what those experts tell us. They conduct the trial. It's trial by jury.
Okay, this gentleman over here, yes, up you go.
Yeah, right. What we're talking about is that the judge is not a judge, correct? What name would you give him now? Take away the fact that he's not a judge. What would you call him?
The old-fashioned word is magistrate. They are an officer of the court. They are part of...
Shouldn't that be the number one thing we should be fighting?
Well,
Just change the label to start off with.
yeah, what's it goes by any other
God.
name?
So basically it's God.
Yeah, so that's why it's been corrupted and exaggerated in their importance, because a judge is when you look at an indictment, I've got an indictment here,
God's a
and
judge.
you go down different sections of the indictment, and it says quorum, C-O-R-A-M. In other words, who's the judge? So it's in the presence of that person, but he's got no jurisdiction. Quorum means in the presence of, but not having any jurisdiction.
John, could I suggest to you that the effectiveness of the jury system, as you would like to have it function, depends very much on the competence, literacy and impartiality of jury members. In other words, how sophisticated they are as people. Now I'm going to present to you a piece of history which you may not be familiar with, and most of the people in this room I don't think would be familiar with it. Some people might. In 1864, I'll just give you a bit of history, and this is interesting from your point of view. In 1864, the then Tsar of Russia, Alexander II, initiated a raft of reforms, not just the emancipation of the serfs, which he did in 1861, he also initiated town councils called Zemstvos, and he also initiated trial by jury, which had never existed in Russia up till that time. We're going back to the 1860s. Now, his son, Alexander III, who was a very limited man, restricted that after his father was assassinated in 1881. But in the late 1870s, there was a sensational trial in Russia by jury, and the defendant was a young lady by the name of Vera Zhizhlik. Now, Vera Zhizhlik had shot an unpopular provincial governor of the Tsarist regime. She had pointed a gun at him and shot him. She was technically guilty. The jury acquitted her because the jury was in sympathy with her cause, and she went free and escaped from Russia and joined the revolutionary movement in Western Europe for many years, and was, I think, at a later stage, a colleague of Vladimir Lenin's. At least she belonged to the Iskra group. Now Vera Zhizhlik was released and deemed innocent by a jury of her peers, who were Russians at the time, who were, one, perhaps not very sophisticated people, and the literacy then was not very common, and secondly, were very sympathetic to the revolutionary cause which she represented in their eyes. In other words, she was a heroine, and therefore they acquitted her. Okay, now, yet she was technically guilty in the highest degree. Whether you are sympathetic with the cause or not, she was guilty of what she had done, and she escaped. Would you like to comment?
Well, as you probably know, there are two elements to an offence. There's actually committing the offence, and there's having a guilty mind. If you don't have the guilty mind...
She did it intentionally. It wasn't accidental.
This is why the jury, even in the practices and procedures of the New South Wales Supreme Court, it says that the jury must act purely according to their conscience. Their conscience. They decide. In fact, when you say she was obviously guilty,
well, there was no question that she had done that which she was indicted with.
But the word guilty doesn't mean say you've done something. It means you've done wrong. That's what the word guilty means. So as far as they're concerned, she has not done wrong.